All right. Now we are ready to begin oral argument in cause number 1, CA CV 150477. This is Albert Ray Roberts versus Jeremy Wills. These proceedings are being both audio and video recorded, and we've taken a lot of time to set them up while you were waiting, so that should be verification to you. So barring any unforeseen problems, you can critique yourself on YouTube in a couple of weeks and go with it from there. How's that? Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try and leave you some time to do that. However, ultimately, your reserving the time is up to you. We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and the issues attendant to this argument, and we offer that up to you so that you might decide based on that how you want to tailor your argument, because it is entirely in your hands at this point. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, appellant, you may begin.
Thank you, Your Honor. May it please the Court, my name is Mick Levine. I represent Albert Ray Roberts in this matter. I think what this case really comes down to is whether holding a garage door up by bungee cords is a defective or a dangerous condition.
Well, before we
Didn't get very far into that, did you?
happens. Before we get to the substance, we have essentially two appeals, where one involving Debbie, and you got 54B language, which sets the time for filing a notice of appeal. That didn't happen.
I'll be more than happy to address that one first if you'd like. Okay, so 54B language. Was 54B language appropriate in this circumstance? If it was, you're right, our appeal is untimely. If it wasn't, then our appeal is timely.
To raise the issue of whether it was timely, you still have to file an appeal from it and say it was improperly certified. You can't wait until, let's say, you get a 54B judgment and then say, oh, I have unlimited time to appeal, and raise that it was improperly certified. You still got to take the time to appeal. You've got a final judgment, whether you like it or not.
Let me see if I can address that. I'm trying to wrap my mind around that. If I get 54B language that isn't appropriate and I appeal, isn't the court going to say your appeal is too early because you have 54B language that isn't appropriate?
Your first argument on appeal is it was inappropriate to enter a 54B judgment. And then, you could argue the merits of the judgment if you want to, but we're statutorily bound by 30 days.
But if I have 54B language and it's inappropriate to have that 54B language, then there's no way to get to the merits because the appeal would be too early. It would be before it was supposed to.
Because you have a 54B judgment. Time's running. By the rule in the statute, time's running.
Okay.
So you file a notice of appeal. You can move to have us determine whether a 54B on a motion where the 54B was determinative or not, or in your first argument on appeal is this shouldn't be here. This 54B judgment 54B language was inappropriate. If we agree with you, then we say fine. Well, you can't wait. What you can't do, I don't think, is wait. Or at least I know of no authority that says you can wait beyond the 30 days, wait till the rest of the case is decided, and then say, oh, I'm attacking the 54B judgment.
Okay. I'm not going to argue with the Court of Appeals judge as to whether or not I can or I can't. But this is a 54C case. I mean, we do have a case that was completed. It went to the end. Yes. I understand that we have 54B language, right, but if that 54, right. My argument for the purposes of the court, though, is that if I have 54B language and it's inappropriate, then I couldn't appeal. I don't have to appeal that until 54C is entered.
Do you have any case that says that?
No.
Okay.
Nothing other than the rules.
When the trial court said, I'm going to enter 54B language, you said, no, Your Honor, don't do that.
Okay.
No, I'm asking, did you say, no, Your Honor, don't do that?
I don't believe that we took up with the court at that time that 54B language was inappropriate. No.
So aren't you kind of stuck with that then?
Right, and I understand what your honors are saying, which is probably why I led off with the meat of this case, which is whether or not we have a dangerous or we have a defective condition. As I understand it from the case law, what Pruse holds is that if you have a defective condition, then that doesn't necessarily mean that the homeowner or the property owner has any duty to warn, to do something about it, to reasonably address the situation. But if you have a dangerous condition, then you do. So we have, in this case, with Jeremy Wills, garage door being held up by bungee cords. Obviously, the danger here is that garage door is being held up not by the way that it should be, not by the mechanical means that are built into that garage door, not by the electrical means that are built into that garage door, but it is, if you don't mind the expression, rigged up there. Now, what's the danger involved with having a garage door rigged up there? That it will fall. What happened in this case? It fell. The exact method of how it came to fall, that's questionable. We have heard that when it fell, it came off the tracks and that Ray was in the process of holding this garage door above his head so that it didn't fall on top of him. He had a couple of helpers come up to him. They came, they helped try to put this thing in there while they were trying to put it back in the track and get it off of the top of his head where it would have fallen and hurt him. Some cord snapped, cut his hand, broke his pinky. That's what the case is. So let me start with actual notice. Does Jeremy Wills have actual notice, or at least sufficient notice for us to be able to ask that question of a jury? What the jury knew was that Jeremy Wills knew for at least 2 weeks to 2 months that this garage door was being held up by bungee cords. He knew that garage door doesn't normally get held up by bungee cords, and he did nothing about it. That's actual notice that we have a dangerous condition, not just a defective one.
Did the injury occur because the bungee cord broke?
We don't know what exactly it was that broke. All that we know is that this thing fell down on top of Ray while he was trying to open it. Could have been a bungee cord. It could have been some other cord involved in the guts or mechanics of this thing. Ray does say that it was a cord that hit his hand and broke his pinky. But what kind of cord, I can't answer for that.
The day this happened, this was the first time he had opened the door, correct?
That was his testimony, yes, Your Honor.
Okay, so it's something that he had not exposed himself to, or that the owner had taken care of or responsibility for up until the day he elected to do this for himself. Does that change the equation?
Does that change the equation as far as whether or not there's a duty and whether or not that duty is breached? No. As far as causation, perhaps, but that's not what this case is about. This case isn't about whether Ray could have foreseen that this problem might occur based upon what he knew or anything like that. What this case is about is whether or not there's a duty and what the extent of that duty is.
Did he change the duty at the time that he chose to do something that maybe the other people that had been opening the door for the last umpteen weeks had not done?
I don't believe so. Under these circumstances, a homeowner has a duty, or an owner, possessor of land has a duty of reasonable care to somebody who's on his property. And we do have this invitee versus licensee type of argument that was talked about some in the briefs. I'll get to that in a moment, but I think what we're looking at here is what is the duty that a homeowner owes to somebody who's come onto the property. And in the invitee situation, it's a duty of reasonable care.
But can the invitee change the circumstance and thereby alter, after the fact, what it appears the duty was?
I believe the answer there is no. We do have comparative fault principles that might apply, or assumption of the risk principles that might apply, but it doesn't change what a homeowner's duty is when they know of a dangerous condition on their property. A homeowner's duty when they know of a dangerous condition on their property is to do something about it. And if I remember right, it's should the owner, in the exercise of reasonable care, discover and correct it. That's what the case law says.
So really, the crux of this case is the specificity of the danger.
I believe that's exactly what the crux of this case is about. Yes, Your Honor. It's about the specificity of the danger. Now, Jeremy Wills may not have known the specifics of how this thing was going to create a danger to Ray Roberts or anybody else on his property, but how close are we going to split those hairs? He certainly knew that there was a condition on his property that was not how it should be. This garage door being held up by bungee cords, let's face it, this is a rigged together solution in order to make something work, but that doesn't mean that it's safe.
But as I understand it, the injury occurred because the door fell out of its tracks, not because of any issue with the opening or closing as it pertains to the bungee cord. As your client was trying to move the door, it fell out of its track.
And I believe that he was moving the door to open it, and as he was opening it, it fell out of its track, and he said that he had to hold it above his head. So what we do know is that there's a problem with this garage door, that it has to be held open with bungee cords. And was it the bungee cord itself that failed? No, it wasn't the bungee cord. It was something to do with the garage door. We knew, I'm sorry,
go ahead.
but we knew that something with that garage door had already failed. Otherwise, it wouldn't have had to have been held open with bungee cords.
But what actually caused the injury was the door falling off of its tracks?
No, actually not.
Okay.
What actually caused the injury was after the door fell on top of Ray Roberts, he was trying to put it back onto its track, get it off of his head. He had a couple of helpers there trying to get it back on there, and as he was trying to prevent this thing from falling on top of him, he says a cord snapped, caught his hand, cut it, and broke his pinky.
Okay. And do you have a specific reference in the record where that testimony is that there was the cord that caused the injury, the cord snapping that caused the injury?
I believe that is in our briefs, Your Honor. I'd have to take a look in order to find it specifically.
If it's in your brief, we'll find it.
Okay. And if it wasn't in ours, it's probably in defendant's. So what it boils down to, I think, is the difference between the Pruce case, if I'm pronouncing it properly, and the Whiting case. In Pruce, what you have is you have a planter, it's got some rocks in it. The property owner knows that from time to time, people will go across that planter putting rocks onto the walkway. And the rocks on that walkway are a dangerous condition. Whiting's a little bit different. In Whiting, what we have is we have some trees where the branches are falling into populated areas. Now, in Whiting, though, it's not the branches that actually cause the injury. What happens is that one of those trees falls over on top of somebody and kills them. Now, the idea here is that you don't have to know the exact method of the dangerous condition. All you have to do is know that it's a dangerous condition. We're not talking here about a garage door that has some kind of defect with it and Ray getting hit by a car. We're talking about a dangerous condition involving this garage door that ends up causing injury to him. Now, I want to talk for a moment about constructive notice. Constructive notice is a little bit different. That is that you know that there's a problem, you choose not to look into it, but you ought to know that there's something that needs to be done here. The court in Cooley talks about constructive notice. In Cooley, what you have is the length of time that there's a defect. You also have the nature of the defect. Here, the nature of the defect is that this garage door has to be held open by bungee cords. The length of time is 2 weeks to 2 months based upon Jeremy Wills' testimony. So should Jeremy Wills, under the exercise of reasonable care, have known that something was wrong with this garage door such that it might cause injury to someone on his property? And I think the answer there is yes. He knows that this thing has to be held up by bungee cords. He knows for at least 2 weeks to 2 months that something needs to be done about it in order to get it into its proper, normal condition so that it works.
Was he the only one who knew about the bungee cord?
No. Apparently there were a couple of Ray's workmen who worked there who also knew about the bungee cords. Jeremy knew about the bungee cords. Jeremy's mother knew about the bungee cords.
Your client knew.
My client knew that there was bungee cords involved in somehow holding this thing up, yes. But as a property owner, he has the responsibility here. Ray's a workman when he comes here, and that's what I want to talk to you about a little bit on the invitee versus licensee part.
Well, counsel, before you turn to that,
Yes, Your Honor.
you do cite Kepke
Yes, Your
in
Honor.
your opening brief, and it sounds like Kepke would be controlling of this. Because in Kepke, the court held that Broadway, the department store's knowledge of general construction conditions is not enough. It must have actual or constructive notice of the specific defect which caused the injury, and not merely knowledge of conditions naturally productive of that defect. And there was a chalk line the person tripped over that was part of a remodeling process.
Yes, Your Honor. And
So how is that case distinguished from this case?
Sure. There we're talking about Broadway having a general knowledge that at some point in time there's some construction that's done. We're not talking about something as specific as a garage door that's being held open by bungee cords. Kepke's distinguishable from this particular case because Broadway in that case knew that there was construction, but they didn't know the specifics of what was out there, what was happening, who was doing what, that type of thing. Okay. Now the general contractor in that case, that's a different story. The general contractor in that case would have known that they had a chalk line across the floor, and the general contractor probably would have been responsible for having a dangerous condition on that property.
So you're saying that
I think what I'm getting at, Judge, is how specific do you need to know?
How specific do you need to know? And if he was injured by a cord snapping when they were trying to put the door back on track, how could the homeowner know that was going to happen?
Look, and we're talking about a chain of causation here, okay? What the part is that starts here is the thing is falling down on top of his head. It's while he's trying to prevent this thing from falling down on top of his head that he gets hurt.
I understand.
So I think the negligent, the place that we're going with this, the dangerous condition is that this garage door is being held up by bungee cords. They know that the danger of having a garage door being held up by bungee cords is that it could fall and hurt somebody. But that's exactly what happens here. While the exact mechanism of injury is not something that he knew, the fact of the matter is that he knew that having a garage door being held up by bungee cords could cause somebody an injury.
But with respect, though, it doesn't seem like the injury occurred from the door falling on him. The injury occurred from the cable snapping when he was trying to put the door back on the track. And that seems to be different than, the situation seems to be that there's a bungee cord holding up the door. And he wasn't injured by the door falling on him. He was injured from trying to put it back and having a cable break and apparently cutting his hand and breaking his finger.
I don't think those two items are distinguishable here, Your Honor. And the reason why I don't think they're distinguishable is because he's trying to prevent this thing from falling on top of his head by putting it back. And that's when he's injured. It's kind of like if, there's a car out of control and they don't actually hit you, but you dodge into the way of it while trying to avoid it. It's kind of the same thing. What you're doing is you're trying to avoid injury and you get injured.
So Jeremy should have been aware that if he tried to put the the door back on the track, the cable might break and break your finger.
I think Jeremy needed to be aware that this was a dangerous condition that could cause injury, and the exact mechanics of how it would cause injury is not something that we're going to look into, at least in this particular chain of causation. That's an argument that we haven't really talked about and nobody's actually raised, which is the intervening superseding cause. Is his trying to put this thing back together an intervening superseding cause? It's not briefed, it's not argued, it's not anything that we are talking about. What we are talking about, though, is whether this condition is something that's dangerous and whether he knew about it sufficiently enough to do something about it, which he did.
The problem is you're saying this condition, and I think that's where the problem is when we get back to specificity. Jeremy knew that the door wasn't opening properly, so he rigged it, someone rigged cables. So he knew that it was going to be held up by cables. And the question is, how much did he have to know? How much specific, what's the specific danger that he had to be aware of? Kepke, they talk about mere knowledge of the conditions naturally productive of that defect, that is the remodeling, weren't sufficient. So if I have a defective door and I know it's being held up by cables, do I have to know that, gee, if someone tries to lift it and it comes off the track, and then by coming off the track, a cable's going to snap? That seems to be much more specific. Kepke would seem to support the view that he didn't have knowledge of a specific condition.
But if you look at the Whiting case, what we're talking about in the Whiting case is tree branches falling. Mm-hmm. And these tree branches were a symptom that this tree was old and dying. And eventually this tree, old and dying, fell over on top of somebody. Now, knowing that the condition existed such that somebody could become injured is sufficient under the Whiting case. Kepke is a little bit different because we're going from the general knowledge that there's construction on our property to something very specific as far as somebody tripping over a chalk line. Okay. Now, Broadway's only knowledge at that point is very, very general in origin. Here we're talking about a specific garage door, a specific problem with lifting it up and opening this garage door and having an injury come as a result of opening that garage door. I see I'm out of time. Thank you.
Good morning. I'm Lori Vopel, and I'm counsel for Deborah and Jeremy Wills in this matter. First of all, just very briefly as to Debbie Wills, there's clearly no jurisdiction here. The first time that any argument was raised with respect to the propriety or impropriety of Rule 54B language was in the reply brief when we pointed out that the court did not have jurisdiction. We were surprised to see that argument at all with respect to her in the opening brief. He never filed any objection to the rule inclusion of 54B language. In response to the proposed judgment, there were no objections. He didn't even raise it in a motion for new trial at the close of the case. And so clearly the time to raise those arguments was then, not now. Moving on to Jeremy. The first thing that I'd like to point out and clarify is exactly how this injury occurred. And both under Pruce and under Kepke, Judge Oberbilling defined and identified the dangerous condition correctly. First of all, this is what Ray said, and these are on pages 46 through 47 of his testimony. It wasn't that he was trying to keep it from falling on his head. He said, so anyway, I went over and lifted the door up, and as soon as I started lifting it up, the top panel started coming off. So I grabbed a hold of it. I'm trying to push it up and keep it, the top panel, trying to keep the top panels that were supposed to be in the track. All the wheels are coming out. So he calls Zach to come help him, and they're trying to put the wheels back on. This is not a situation where he's just trying to hold it up and keep it from falling on his head until he can get the bungee cords.
He actually proceeded with the opening of the door knowing it was coming off the tracks.
That's correct. And he never got to the bungee cord part because it started coming out of the tracks as soon as he put it up. And that is how the judge said that the injury here, under Pruce and under Kopke, in every case that has interpreted Pruce, the dangerous condition must be the injury-producing defect, not just that something was defective, and not something that was, even if the defective condition ultimately produced the injury-causing result. That's not enough. Like in Bruce, there they tried to shift the focus, according to the court, by saying, look, there was a gravel here in this rock bed. The Sambos knew that these pebbles would occasionally get kicked out up onto the ramp, and that is the dangerous condition. And the court said no. Even that was not enough. Here you don't even get that much, because there is no evidence whatsoever that what caused the injury here, the panels coming off and the wheels coming out of the tracks, had anything to do whatsoever with the bungee cord. As Judge Oberbilling recognized, it didn't get that far.
So is this a case of the injury coming about as a result of the plaintiff modifying the condition? In other words, if it had been left as it was, no harm. If it had gone up slightly and he realized it was coming off the track, so he put it back down, no harm. Is that what you're saying?
I think that's part of, I mean, that's certainly an argument, Your Honor, but our argument here is that Jeremy did not have notice that it could come off, the panels could come off and the door could collapse and come out of the tracks, and could not have had notice. And because of the fact, and I'll want to clarify a couple of things with respect to the amount of time. Jeremy admitted in his trial testimony that he had said in his deposition that he knew something was wrong with the garage for 2 weeks to 2 months. But if you look at his trial testimony on page 190 and 191, you'll see that he said that where he's coming up with the 2 months is this disputed testimony where he says it was 2 months ago that we signed the contract and we had Ray there. And Ray pointed out that the garage door wouldn't open, and he wasn't sure if it was locked or if something was wrong with it. That is all the notice or information that Jeremy said he had until after they got the keys. And that was approximately, according to Ray's own testimony, about 7 days before this occurred. And so the same day that they got the keys and took possession of the home was the day that Ray came over and they went through everything and they looked at everything. At some point, in the first or second day, some point in that time period, Jeremy says Ray is the one who told him there was something wrong. But you don't even have to get to that disputed testimony, because Jeremy let everybody know, and this is according to Ray's testimony, according to Zach's testimony, according to his own testimony, according to Eddie's testimony, that he let them know, look, the garage door won't stay open by itself. You have, and he says he didn't know about the bungee cord system, but he knew that somehow it was being held open. It's disputed who set up the bungee cord system, who was opening the garage in the morning. The testimony is disputed with respect to that. But there is no dispute that this young man bought this house, took possession of it 1 week before this injury, and his knowledge that he knew, that he found out, regardless of how, about this garage, that it wouldn't stay open on its own and had to be held open with bungee cords, that was communicated, and it was the exact same information that Ray had and that both Eddie and Zach, the workers, had.
So back to something I was addressing with counsel. You say that Jeremy told Ray the garage door will not open. Is that correct?
No, Jeremy said that Ray, this part is disputed. Jeremy said that Ray came 2 months earlier when they signed before they signed the contract, because they wanted Ray to go through it with him, given his construction background and the fact that he was family, and that Ray tried to open the garage door from the outside and it wouldn't open. And so he pointed out, look, I don't know if it's locked, or I don't know what the situation is. That's where this 2-month estimate comes from. So all he knew then was it wasn't opening. He didn't know why.
But the best information he had, wouldn't any duty that was established be based upon the knowledge that was exhibited, the knowledge that was expressed? The garage door does not open?
No, because he said that Ray told him it might need a key. It could be locked. And so that's all he knew at that time. They didn't have possession of the house at that point.
At least a week before the argument.
A week before
the
injury.
incident.
Correct.
The accident. Jeremy knew that the door wouldn't stay open on its own and had to be held up by bungee cord. No matter who put the bungee cords up there, he knew it was being held open by bungee cords.
Correct.
But did not know that if you tried to, I assume, close the door or open the door, whichever it is, and do it manually by lifting it, that the panels the door would fall off a track and then could fall and hurt someone.
That's correct, Your Honor. Zero evidence in the record. And that is why the judge granted a directed verdict
why
here.
Is this different than the City of Phoenix versus Whiting case?
The Whiting case, first of all, I'd like to point out, first of all, that preceded Pruce. And so Pruce, although it didn't overrule it, it was really, I mean, Pruce has really set the standard for really what puts somebody on actual notice and how you define the defect. Also in Whiting, all of these, the city knew, first of all, the city has a somewhat elevated duty here to keep roads reasonably safe for the traveling public, more so than a brand new landlord owner who just bought this home, okay? But secondly, the city employee who was responsible for maintaining these trees testified that we all knew that these were very, very old trees, was his testimony, that there were conchs on the trees, conchs, holes that developed that show rotting, that the tree is rotting. That tree and other trees right beside it were rotting. Branches had broken off, fallen off, etc. And so the court basically said that's enough under those conditions, that they had enough knowledge that these could be problematic trees.
Limbs had been falling off.
And because they had conchs and they were very, very old, correct.
They knew that those two things, the conchs were going to cause limbs to fall off.
No, that the tree was rotting from the inside. Right. Correct.
And therefore, limbs would fall off. Or the tree could fall over.
The tree could potentially fall over, they said was enough. And again, they said basically, and it was a close case. If you really look at the language in that case, they're saying, yeah, I guess that could go to the jury on whether they, on whether there was knowledge there or enough to put them on constructive notice. But Pruce and every case since that time has said, no, you don't get to let the jury speculate where there's zero evidence. They didn't bring in some kind of an expert who said, yes, these were connected. When a garage door like this won't stay open, you've got a problem. This thing could come off, the panel could come off, it could come out of the tracks. Zero. In fact, all of the testimony, even Ray's own testimony, as Judge Oberbilling recognized, was that it coming out of the tracks and the panel falling off had nothing to do with the bungee cords. They all knew and understood that the purpose of the bungee cord was to keep the door open once you manually opened it, period. Everybody, as Judge Oberbilling recognized, had that exact same knowledge for 1 week. And you have Jeremy here who has no experience in construction whatsoever. They're adding on these jobs, everything, for Ray, hey, take a look at this, take a look at that. And although there's testimony that's conflicting as to whether, he had talked to Ray, and I don't even think Jeremy said he talked to Ray about it, but he expected that at some point, or I guess he actually said that he said eventually he would take a look at it. The bottom line is that you have a person who has very superior construction knowledge and a young man who brings him in to help him get the home ready, and they all have the same knowledge that this door won't stay open without the bungee cord system. No evidence whatsoever that because it couldn't stay open, that could cause it to come out of the panels to come off, that it could cause it to come out of the tracks, etc. And so, and again, if you look at these cases, are very, very specific. Proofs. The notice must be of the defect itself which occasioned the injury.
Does it matter in proofs that it was a transitory nature? In other words, you have a planter with rocks, and some of the rocks fall on the sidewalk. That could change day to day. Kids come up, they throw the rocks on the ground, wind comes up, blows some of the rocks over. Here it's something that's not the case.
First of all, that
Effect in the wall, in the door.
First, just to point out, that argument wasn't raised until the motion for new trial, but I don't think it does make a difference. And the reason is that if you look at Cooper and these other later cases, they both talk about that it is, let me find the Cooper case, I apologize, or Cooley, excuse me, the Cooley case and the Haynes case. They talk about that, for example, Cooley and Haynes both involved this deteriorating sidewalks, okay? Or, in Haynes, actually, it was that in Cooley, there was a portion of the sidewalk that had lifted, and Judge McGregor actually dissented and said, no, judgment as a matter of law was appropriate there because there was no evidence that it didn't just happen that day. Setting that aside, there was certainly at least enough in both of those cases to say, look, these were deteriorating for a long time. The workers had told the owners of these properties that the apartment complex, and I think APS was the other one, that this condition was here and it was getting worse and it needed to be fixed. So they had actual knowledge, they had constructive knowledge. But both of them focus on, and Cooley even says that it found its case with the raised sidewalk akin to the Haynes case because it was neither transitory nor one that arises suddenly. So it's not just that, well, if it's kind of a nature transitory kind of producing result, it doesn't have to be that kind of a thing. It can be a condition that arises suddenly. And all of the evidence in this case is that that the dangerous condition arose suddenly and that no one knew, no one had reason to know, no one could have known within that 1 week period that this was going to happen. And they all conceded that.
But Kepke seems to go even further, because there the chalk line wasn't it was transitory in a long-term theory, not on a daily, maybe a daily basis, but it was something that was going to be there apparently for a while, and the general fact that remodeling is going on isn't enough.
Correct. That's correct, Your Honor. And I think that case is, and I didn't specifically discuss it because I should have, because I really felt that Bruce focused on that and defined that very clearly. And that's just evidence of yet another case that defined the defect, that you can have a defect. That doesn't mean that the defect is a dangerous condition. You cannot just equate the two, even if under Bruce, that's what kind of is awesome to me and unusual and shows the degree of specificity, is that Bruce said, even though they knew that rocks could be kicked out of the planter, that wasn't enough to put them on notice that those rocks were on that entrance way on that day, and directive verdict was required. And here, again, there's absolutely no notice, there's no evidence that anyone knew, and all of the testimony is that no one knew. maybe the prior owner knew. That's, I guess, a possibility. I've thought about that, but certainly there's no information or evidence that came out that the prior owner even knew about this. So what is the undisputed evidence shows that Judge Oberbilling was required to grant directed verdict on the evidence in this case, and that there was nothing that showed actual notice or that could have given rise to constructive notice. Does the court have any more questions? Okay, then I will sit down. Thank you.
You done?
Done with this case, I think.
Okay, I guess we're done, counsel.
Got to ask the bailiff.
I need to ask the bailiff if we're done. Folks, we have focused our direction, our questions at the issues we had. You certainly started out right in the middle of the grill, and please understand that those are where our concerns lie. Predominantly, we have addressed those specifically. So, to the extent that you didn't get a chance to redirect, we're looking at the totality of the case. We're going to take this under advisement at this time. We will issue our order in due process. Thank you very much for your argument today. A couple of skilled arguments, well presented. It's been an interesting discussion. Thank you for that. We're adjourned. And if the next case is ready.